Thing that makes that I'm aware of that makes information that takes place in executive session confidential. It allows public officials to keep it confidential, but it doesn't require them to keep it confidential. To my knowledge, that's my reading of the Open Records Act.
My understanding of the ethics section of the City of Springfield section says that they will do everything they can to protect the information of the city, or to protect the city's interests. If the city wants to buy a building, whether there's any financial gain from the mayor at this point or not, I think is irrelevant. The issue is if that information is told, especially to a person who is head of the committee for the businesses in downtown, who knows everybody and talks to everybody, if for some reason somebody goes out and buys that property ahead of the City of Springfield, knowing that the city wants that building and needs that building, to me, that's a violation of city confidence and city information. That puts the city in a bad position where the city no longer has the ability to buy that building and now has to pay more.
Specific now, was all that information available to him?
Oh, yes, sir. Yes, sir. I believe it was.
Well, and what you're telling us is it was a violation of the city's ethics rules, but the trial court said it was a violation of the statute, and I don't see him saying anything about violating the city's ethics rules in that respect. So you seem to understand it and have a theory, but it doesn't seem to be the same one of the court whose judgment you're trying to defend. I'm looking at the paragraph I think Justice Melton was looking at where he says he's violating OCGA 50-1872, but you're saying, well, that's not it at all. He was actually violating the ethics rules.
Yes, sir. I understand what you're saying, and I honestly don't have an answer for that question. I don't.
It seems to be the trial court didn't have notice of what you were proceeding on because he didn't rule on what you're telling us.
I think the two go hand in hand. I don't think you can do one without the other. I think, in fact,
no, you could. The question is, did the mayor have notice of that, and did you get a ruling from the trial court on the theory you're now trying to defend?
I think that, yes, he did have notice. He had the tape. He understood what the issues were prior to going to trial as far as his conversation on the tape.
I do want to reach the other issues too. How can he be found guilty of violating the statute by talking to his wife or somebody in a furniture store? Explain that, please.
Well, the issue, first of all, when he first went into the store at minute 34 on the tape, the conversation actually commenced because he is the mayor and Jamie Stansel is head of the Business Association in Springfield, and he actually said, I'm not trying to tell you how to be mayor, but, and then the conversation ensues.
Well, just to give you where I'm coming from, if the mayor went in there and said the city council is just a complete bunch of rascals, that's not a violation of any statute, and nor could you make that a violation of any statute. How is that grounds for removal?
And I think this is where the question of undermining the authority